Welcome back. I'm Carissa Kranz. We are continuing our live trial with the Van Dyke case out of Illinois, 2014 case where a former Chicago officer is standing trial for the murder of a 17-year-old teen, Laquan McDonald. The question is whether it was reasonable for this officer who arrived on scene to shoot and kill 16 shots within 30 seconds of him arriving and within 6 seconds of getting out of the car, unloading his barrel of gun when other officers were already on scene and didn't really feel threatened. So far, that's what we're hearing from the prosecution. With me, we have another guest, Alan Tuerkheimer, and he is a jury consultant, and Rahul, who's also on screen with us. But Alan, I want to give you the opportunity to talk right now and let us know your thoughts as a jury consultant on the jury composition of this case. And just a quick recap, the jury composition is 8 women, 4 men, 7 whites, 3 Hispanics, 1 African American, and 1 Asian American. What are your thoughts after seeing the opening statements, the facts of this case, and that jury composition?
Sure. Well, one might wonder why there's just 1 African American on the jury, and it's pretty typical of a Cook County jury. And given the issues of the case during voir dire, jurors were asked pretty pointed questions about whether they can be fair. And so after you get through the exclusion process, both sides ended up with the composition the way it is. But it's pretty typical. You can see a lot of Cook County juries that are mostly white, 3 Hispanics, and an Asian, and one African American. So it's not that unexpected. Each side just gave a roadmap of what they're going to offer for the case. And not surprisingly, the prosecution, as you were alluding to, talked about how Van Dyke was the exception rather than the norm, that Laquan McDonald wasn't threatening anybody, that the other officers are saying just that. They didn't fire 16 shots at him, and they're using the video to try to connect with the jury and plug into some of those emotional impulses. The defense is going to do the opposite. We're saying that, no, it's not true. Laquan McDonald had a knife in his right hand. He tried to stab this gentleman who was in a truck. He punctured the tire of a police car in the windshield, and he was out for something bad. And that Officer Van Dyke didn't do what he did. He might have harmed somebody else and done more damage. And they also said, yeah, 16 shots, hard to get around that, but they're saying that when an officer fires in a situation like that, it can get off 5 or 6 shots in a second. So it was night, and he didn't see exactly where the shots were going, so he had to keep shooting to make sure that he hit his target, which sadly he did.
All right, I appreciate your insight in that. You've obviously been following this trial closely, as have we on the network. We have a live feed in the courtroom now, so let's go live back into the courtroom and see what's going on, and then we'll have some more in-studio analysis. Welcome back. We are watching the Van Dyke trial live in the courtroom. Right now there's a sidebar that the judge is listening to with some kind of safety issues, security issues. So perfect time to bring on my guests because I have 2 of them. We have Alan and Rahul. Let's talk about Rahul. I want to give you the chance to talk about the jury composition because that's where Alan left off. Do you have any comments there? I know that you're not a jury consultant, you're more of a defense attorney, but it's your job to voir dire jurors all the time.
Absolutely, and in a situation like this, it's kind of a no-brainer. We all know where this is going to go. In terms of peremptory challenges and whatnot, you really want to make sure that the jury accurately reflects the society that you're in. But at the same time, you also want to get rid of the ones that you think may or may not be problematic. And these are why you ask certain questions, why you vet them, tooth and nail, you kind of go through it. And it's a science unto itself. Jury selection is a science unto itself. Sheaves of books have been written about the subject, taking into account psychological issues, socioeconomic issues, educational issues, the whole nine
But
yards.
what about the fact, and Alan, I'll let you comment on this real quickly, we don't have a lot of time, that we have a video that shows pretty clear, which we see replayed over and over, of him running away and being shot and falling to the ground and then getting shot again.
Yeah, it's hard to get around that, and the jurors were asked about it, and the defense has to widen the story and provide context, and ultimately try to reach out to jurors who believe that if you look at everything and take a comprehensive look, that he was justified in doing that. It's really tough to do. A lot of people have seen the video, even some of the jurors.
All right, sorry to cut you off. We got to take a quick break, but we get the point. Thanks for the insight. We'll be right back after this message. Welcome back. I'm Carissa Kranz. Okay, a lot to dissect here. We're listening to the Kody Lott case out of Texas. This is a case an insanity defense case. And right now you're listening to a defense witness, because the state rested this morning, a psychiatrist in the name of Dr. Brian Falls, sit here and dissect and tell us why the defendant is insane. A couple takeaway points I just picked up from listening to his testimony right now on direct examination is the following. One, he thought that the devil told him to do this, and he was working in concert with the devil to save the victim's life, Lauren. He thought that the victim, Lauren, was an angel and that God would save her, and that if he didn't kill her, something much worse was going to happen to her. Number two, he doesn't seem to appreciate the difference between right and wrong, because he thinks by killing her, he's doing something for the betterment of society because God's going to protect her and this would be her straight ticket to heaven, and that the devil was then going to protect him. Third, we're listening to how delusional he was over some opioid addictions and some other disorders, a weed disorder, et cetera, et cetera, et cetera. Rahul, criminal defense attorney, how's he doing on the insanity defense?
I mean, this is another one of those cases where the geographical location is very significant, just like the Chicago matter beforehand. We talked about the civil rights problem there. Well, you know, in Texas, I mean, they tend to be a little, actually kind of no nonsense in terms of civil rights. So I'm actually surprised that they're getting this much mileage out of this insanity schizophrenia defense, because to be very blunt with you, I mean, that's not really even, you know, that's not really a mechanical problem with the brain. That's, you know, a psychological, sociological issue which could be kind of argued away by forensics. So I'm actually very, very shocked and surprised they're getting this far with this kind of a defense. I don't think there's
now that they got this far, do you think it could be a successful defense? I mean, I'm listening to this testimony and I'm thinking this guy's delusional. I think the question's going to be, how does this doctor do on cross-examination when it's the prosecution's turn to poke holes in the defense's argument? Because I'm listening to this, and if the devil's protecting him and God's telling him to do it, how is he not delusional and legally insane? Well,
again, you know, I don't think he's going to get very far in a Texas courtroom with this kind of a defense.
So you're saying it's because of Texas?
Well, no, it's just culturally, you know, I just think absent some sort of physical manifestation of an injury, like a nervous disorder, you know, some sort of neuronal, you know, sort of, you know, end result, I really don't see him getting out of it. I mean, Texas has no nonsense, culturally speaking.
They have no nonsense, but he already was able to get himself to not stand trial for being incompetent and then rehabilitated to be competent. But if he was found incompetent, he obviously has some mental issues. The question is, does it rise to the point of legal insanity?
Again, you know, the standards for that kind of thing are very low in states such as New York, you know, in Los Angeles, Miami, California, that kind of thing, urban areas. But in rural areas like this, you really don't see them getting away with things like this. I really think that they're going to be grasping at straws. I don't see it happening. The reason that it's still in litigation right now and it's going back and forth is because it is Texas.
All right, well, we'll see what happens. We're going to continue to monitor this trial, but first we have to take a quick break. And just so you know, the Van Dyke trial is also on break for the rest of the day, so tune in tomorrow to pick up the rest of that trial. Stick with us. We'll be right back for this one. Welcome back. I'm Carissa Kranz. We are continuing coverage in the Kody Lott trial out of Texas. This is the insanity defense case for the alleyway middle school shooting. And right now on the stand, we have a defense expert, a psychiatrist, Dr. Brian Falls. Sorry, I lost his name for a second there. Thank you to the control room who whispered it back into my ear. I want to bring with me out to discuss this, Alan, real quick, because we got cut off before the break. I wanted to give you the opportunity to talk about the insanity defense here and whether or not you think it's an effective defense.
I think you have to play the hand you're dealt. It sometimes can be, and as Rahul said, a lot of it depends on the venue, but it's really hard, and I've noticed over the years, jurors have a really hard time buying it. They feel like they want closure to something, and especially in this case where I think the perpetrator, the defendant, was in love with the victim, I think it's really hard for jurors to get around that and get behind it. So it's an uphill battle for the defense. Mm-hmm.
And if they find him guilty but insane, or not guilty by reason of insanity, do you know what will happen to him next, procedurally?
I'm not sure. I think they might have some kind of mandatory clause that says he has to go to an institution where he's, maybe there's some kind of security involved there, but I don't think he gets to walk. I definitely think there's some, probably depends on law down there, what happens.
That's what I remember also in the state of Florida when I was a prosecutor, that if someone is found not guilty by reason of insanity, that they may not be going to a prison, but that they could then spend their life in a mental facility for some indeterminate period of time, while they are considered legally insane, or, temporary insanity in certain cases as well. So, Rahul, do you have any insight on that before we go back to court?
I agree with Mr. Tuerkheimer. The geography has a lot to do with this. I don't see an insanity defense working in the state of Texas. I just don't see it happening. And to be honest with you, it's still in litigation. It's been going back and forth. They found him insane, and they don't find him insane. I really, there's enough reasonable doubt on the prosecution side that he's not insane, that he's competent to stand trial. So I don't see the Texas judge letting him slip out of...
Competency and insanity are two different things. One's whether or not you're competent to understand what's happening in your trial to stand trial, and therefore stand trial and have a fair defense put on in your favor. The other one is saying whether or not you were legally insane at the time it happened, legally insane now, or legally insane in general. And the jury gets to pretty much decide whether or not, one, he committed the acts, and then two, if legal insanity, not insanity, because arguably anyone who commits a crime is insane and delusional, but whether it raises to the level of legal insanity as a justified defense to find him not guilty under the circumstances.
Right, but people lose sight of the fact that criminal law is state-specific. It's not federal law. Every state has its own criminal penal code, and cultural issues come into play there. Whether or not, the immigration system, for example, or the patent system, they're trying to make uniform laws, criminal laws, what's an aggravated felony, what's a crime of moral turpitude, but that's a really hard slog. The reality is Texas, it's very, very difficult, culturally speaking, as well as in the penal code, to prevail on an insanity defense, as opposed to, say, New York City or Los Angeles or Miami or major cities. They tend to take a no-nonsense approach to these kinds of issues. I just don't see... the insanity defense, I don't think they've proven their case. I really don't.
Well, we'll see what they end up doing. It's going to be the juror's decision ultimately, and the standard, I believe, is also a little bit lower. But we will see. Let's go back to court, because we have a live feed, and this doctor is still testifying for the defense, making his case. Welcome back. I'm Carissa Kranz. Right now on the stand, we're still listening to the psychiatrist testify for the defense in the Kody Lott trial, saying that he was legally insane and therefore he should be found not guilty. While we were listening to this, I've turned to the computer and to some research here to try to see what would happen to him in Texas and what's the standard. And I learned some interesting facts. One is, if the jury finds him guilty or not guilty by reason of insanity, then the judge gets to commit the defendant for a time up to the prison sentence. So in this case, this would be life in prison, to a facility. That is the judge's decision. And the jurors do not get to know what happens to him after they return their verdict under Texas Penal Code. And in fact, the jurors may even think that he may get released. Furthermore, what I just learned in Texas is, if the defense proves by a preponderance of the evidence, that's the standard, a preponderance of the evidence, that the defendant was guilty at the time of the offense, the state can only prevail by proving beyond a reasonable doubt that he was actually insane. So the burden shifts against the state. So while Rahul and I were talking how this is a tough defense and how it's not easy to ever bring an insanity defense argument, by reading the Texas Penal Code and reading the case law in Texas, it seems like that the law favors the insanity defense and the defendant when you're able to prove beyond, for a preponderance of the evidence. That's more likely than not. That's 51%. Is it really just possible that he was insane at the time of this? And when you hear he was working in concert with the devil and that he was protecting the victim because God said something worse was going to happen to her, which means he didn't appreciate the difference of right and wrong, which means the McNaughton test, the rule that they apply in Texas, which is knowing the difference between right and wrong, the defense just won on this issue, if I'm hearing this right. Do you agree or disagree?
I think that your reasoning is absolutely sound, and you're right about that. That's actually very surprising. But the judge can, intervene at that point in time, you know. But you're right. The preponderance of evidence that standard is pretty low.
It's a tough case.
You know, so you may have a point there.
Well, we'll see what happens. Stick with us at Law and Crime. We have to wrap up for the day. I want to thank Alan for being with us and Rahul for being with me. And I will be back here tomorrow from 12 to 3, but we start at 9 a.m. Stick with us. Watch our jam-packed trials. We always cover everything.